Welcome to this edition of Elder Care Answers. Elder Care Answers provides valuable information for senior citizens and those who love them, so we can all be more informed consumers.
Hello and welcome to Elder Care Answers, a show dedicated to finding answers to our elder care and estate planning questions. I'm your host, Mary Ravazio, and joining me is Doreen Seaman of Seaman Law Offices, who specializes in elder law and estate planning. Doreen lives and works in Morgantown, West Virginia, where she graduated from the WVU School of Law. Doreen is licensed to practice law in Pennsylvania and West Virginia, but is currently focusing on the estate planning and estate administration needs of West Virginia residents. Hello, Doreen, and welcome to today's Elder Care Answers.
Hi, Mary. I'm so glad to be here.
Now, on your website, SeamanLawOffices.com, you use the term foundation. What do you mean by that?
Well, I like the idea of the foundation to describe a handful of documents every adult needs to have. This includes a durable power of attorney, a last will and testament, and 3 important medical documents. These are the documents we include in most estate plans because they are so vital.
It reminds me of that old Sunday school song about the man who built the house on the rock and it stood firm.
Yes, like building your house on solid rock, you should also build your estate plan on a strong foundation with the help of an estate planning attorney. This will ensure that you are prepared for life's unexpected turns.
If someone comes to you and says they want a trust, now you don't just hand them a trust document, right?
No, not quite. I help my clients reach their goals, which are very specific to their personal concerns, and that's why I offer a complimentary consultation to get to know them and understand what they'd like to accomplish and what concerns they have. Usually there are issues that are red flags to me, meaning they might not realize there are issues we need to address in their estate plan that I know from my experience in estate planning.
What kind of issues?
Well, let's use an example. We worked with a couple recently who we'll call the Smiths. They initially came to see me to set up a revocable living trust.
They wanted to avoid probate, right?
Right. When she called to schedule their appointment, Mrs. Smith said they'd already done their research and they wanted a living trust.
It was great that they were already so well informed, though, right?
Definitely. But during their consultation, serious red flags appeared to me. They had no power of attorney documents and a son with a disability. So we talked about other planning options as well as the living trust.
So that was an opportunity for them to learn about areas of estate planning they hadn't even been considering.
Right. Another way to learn more is to watch our videos that explain some of the different ways to prepare for the future.
Yeah, I know. I've seen those on the website, SeamanLawOffices.com.
They're also on YouTube now, too. At Seaman Law Offices, we're trying to keep up with technology.
Now, when we were talking about the foundation, you mentioned the durable power of attorney. How important is that document?
The durable power of attorney is a document that states who you want to be your agent, meaning the person you trust to manage your financial affairs if you became incapacitated during your lifetime. I call the durable power of attorney the unsung hero of your estate plan because it doesn't sound as important as a will or a revocable living trust, but every adult should have one.
What are the 3 medical documents that should also be included in the foundation?
A medical power of attorney, living will, and a HIPAA release, which all work together to appoint medical decision makers and give those people you trust access to your protected healthcare information.
Why is this also important to estate planning? Why are these documents the foundation?
Let me tell you about a young lady we'll call Natalie. Natalie became my client because of her experience with her sister.
What happened?
Natalie's sister was 27 years old and had been in a skiing accident that left her incapacitated. She and Natalie have always been best friends, and other than a relative that neither of them trusted, they're the only family each other has left. So Natalie, of course, stepped in to help right after the accident. First, she went to the hospital to inquire about her sister's situation.
So I'm sure the doctors discussed everything with her and gave her some peace of mind.
No, there was no authorization to release information to Natalie, so the doctors were legally bound to protect her sister's right to privacy. Natalie's sister needed surgery to repair damage from the accident, but it was a risky procedure. Natalie knew her sister would want the surgery.
So the doctors listened to Natalie and performed the surgery then, right?
Well, the doctors could not act based on Natalie's word because her sister did not have a medical power of attorney. So they had to appoint a medical surrogate, and unfortunately, they appointed the relative that her sister wouldn't have wanted to be involved in her life.
The healthcare providers couldn't know for sure that Natalie would really be her sister's choice for a decision maker if she never put it into writing ahead of time. So then what happened?
Natalie contacted an attorney in her sister's home state to help her petition the court to be her sister's guardian, and eventually she was. But that wasn't the end of the troubles Natalie dealt with.
Well, what else happened?
Well, Natalie tried to work with a bank so she could pay her sister's bills from her sister's accounts.
Let me guess, she wasn't allowed access to the bank accounts either.
Exactly. Natalie's sister did not have a durable power of attorney, so Natalie could not access her bank accounts or expenses. She couldn't pay things like utilities and student loans. Now, Natalie did write a check for the rent, but it was from her own account.
Well, how did all this end? Was Natalie eventually able to help her sister?
Yes. She was eventually appointed by the court to also be her sister's conservator and guardian, but it wasn't easy, especially during a very stressful time.
Wow, that is just all very unsettling.
Well, the good news, Mary, is that Natalie's sister ended up making a full recovery and was very thankful Natalie was there to help her.
When Natalie came to see you, she was trying to avoid the same situation?
Right. Natalie's a mom. So if something happened to her, she'd have all these same financial and medical issues, but there could also be a question of who would take care of her children while she was incapacitated.
How do you address that?
We have the client choose who would be the guardian of their children in their durable power of attorney agreement in case they lose capacity, and also we put it in their last will and testament if they would actually pass away.
These are difficult issues to think about, but isn't it better to plan ahead than to be caught off guard, leaving a mess for our loved ones?
Exactly.
The final part of the foundation is your last will and testament. Now, I was watching a TV show the other night about a guy who died intestate. What does that mean?
Intestate means that the person died and no will can be found.
Well, as the show went on, the court had to determine who the executor of the will would be before they could even start the probate process.
That's correct. That's why it's important to keep your current will where your executor can find it and to destroy any old versions of your will. Probate itself in West Virginia can take at least several months.
But what if you don't have a will? How do they determine who your executor would be?
That's a great question. We call that the race to the courthouse to see who gets there first to be appointed as your administrator.
If you have a will, it appoints your executor. But if you don't have a will, somebody will be approved as your administrator. Is that more complicated and more expensive?
Yes, it's more complicated because there's the question as to who it will be, and then the person who is going to be the administrator must be bonded. We have a client we'll call Lynn. Before she died last year, Lynn's mom always talked about how she planned everything so the 3 kids would get equal shares of everything when she was gone. But after the funeral, no one could find the will.
Did she have one?
No one knows. Either it was misplaced or she may have just thought that they would divide everything equally. Lynn's mom lived in West Virginia, but Lynn and her brothers all live out west.
Does that make probate even more complicated?
Yes, when their mom died, the last thing they were thinking about was her stuff. But after the funeral, they started looking for paperwork. When they didn't find it before they had to go home, Lynn had to fly back to West Virginia within a couple weeks to try again. When she still didn't find anything, she came to me.
Were you able to help her?
We're working on it. First, Lynn and her brothers decided Lynn would be the administrator of the estate. It was fortunate that they all agreed, so it wasn't a contested issue. So we helped Lynn arrange to be bonded and to make her appointment at the courthouse to get the process started. Now we're helping Lynn move forward with a probate.
So meanwhile, Lynn and her brothers are waiting for this process to be completed.
Right. Because they can't settle Mom's affairs and finalize the distribution of proceeds of her estate yet. Plus, they found out the proceeds of the sale of the house might need to be held in escrow for a period of time, and they weren't too happy about that.
So, we've covered the foundation documents of your estate plan, but are these enough to protect your assets? When Elder Care Answers returns, we'll talk about how an IRA legacy trust can protect your retirement accounts. Stay with us. Welcome back to Elder Care Answers, the show that explains how to prepare for your elder care and estate planning journey. Now, before the break, we talked about what should be the foundation of our estate plan. And once we have our foundation, you start building on that, right, Doreen?
Yes, and for some of our clients, that's all they really want and need. But for many of our clients, it's just a starting point, depending on their goals and concerns. It's important for them to understand their estate plan and be happy with it. Often, I recommend a certain type of trust for one reason or another.
Can you give me an example of a trust that you would recommend?
One of the trusts that a lot of my clients have been really excited about is the IRA Legacy Trust.
Now, most of us have IRAs that we put money into over the years to plan for our retirement.
These qualified accounts are tax deferred, which means you didn't pay taxes when you invested in the account, but then you pay taxes as you withdraw the funds from the account. So the issue is what happens when a person dies with money still left in the IRA.
They usually would have designated beneficiaries, right?
Correct. So your beneficiaries would own that account pretty much as soon as you pass away. But what if that beneficiary is a minor? Would you be comfortable with them being able to cash it out when they turn 18 years old, or would you want them to be a little bit older?
Well, I think most of us would agree it'd be better to protect that money for the child's future, but we'd want them to be able to use it if they needed it for important things like college, and maybe somebody we trust could watch over it for them.
Exactly. So if you passed away and you weren't there to guide your child, who's now basically an orphan at a young age, are you 100% certain that they would make wise financial decisions? And are you certain that nobody would take advantage of them financially?
Well, probably not. Especially if they just experienced the trauma of losing their parents, they're probably going to be having a little bit of a rough time.
And remember, when they take the money out, they have to pay taxes on it. So if they took a lot of money out at one time, they might end up in a higher tax bracket, which is foolish if they really don't have a good reason to do so.
Aren't there penalties as well?
Yes, there may be penalties for early withdrawal. So with taxes and penalties, a child could lose about half of the investments instead of stretching it out to mitigate taxes and penalties.
So how does the trust work? Do I have to transfer my IRA to the trust now and then lose control over it?
No. Now that's a really important point. You don't give up control of your IRA now. You just change your beneficiary to your IRA Legacy Trust. So nothing actually changes until after you pass away. Then it's distributed to your beneficiaries as you directed.
But what if they need it for college or a health emergency?
The trustee of the trust, who's somebody you would select on your own, would have the power to use common sense to make sure those types of things are provided for.
Okay, so I see. It's almost like I'd be setting up a pension for my child that could benefit them for the rest of their life.
Yes, of course you understand it isn't actually a pension, but like a pension, it could provide a regular income to your beneficiary over their lifetime while providing some protection from creditors or even a divorce.
If an IRA Legacy Trust can benefit our kids or other loved ones, can we set that up for the benefit of a spouse as well?
Yes, you can. So to make it a little easier, I'll explain how we helped a client we'll call Mr. Jones. Like a lot of my clients, most of Mr. Jones' life savings is in his IRA. So when he dies, he wants that money to provide security for his wife and then his 4 children. Now his son has Down syndrome and one of his daughters is still in high school, and then he has 2 adult daughters. But the first one, the older one, has a rocky marriage and the younger one has a lot of debt.
So how does having an IRA Legacy Trust help all of his family?
Well, with his trust, he can protect his IRA for his wife, so if she needs expensive nursing home care, it won't count as an asset. Then when she passes away, his kids will be eligible to receive the required minimum distribution as determined by the IRS, as long as his trustee agrees that's in their best interest at the time. Now, Mr. Jones also decided to permit his children to withdraw some additional sums of money at certain ages if they wish to. As long as that money remains in the IRA Legacy Trust, it has some protection from creditors and divorce.
So it also means his teenager won't get the money at 18 years old. She'll have to wait till she's a little older.
Exactly. And there are provisions for Mr. Jones's special needs son as well.
Great information, Doreen. So while an IRA Legacy Trust can protect your retirement accounts, what about your other assets? After the break, we'll talk about revocable and irrevocable trusts and which ones are right for you when Elder Care Answers continues. Welcome back to Elder Care Answers. Now, Doreen, earlier you mentioned the Revocable Living Trust. And if I remember correctly, a Revocable Living Trust is an awesome management tool that lets the owner continue to be in complete control of his or her assets as long as they are alive and have capacity, right?
Yes, you've got it.
All right. Now, we do that. So if we do lose capacity or we get sick and need some help, we have a backup trustee to help us. And of course, we also avoid probate.
I see a lot of my clients who are the executor for a loved one's estate who don't want their family to have to do that for them. These are usually the clients who say something like, I don't want to leave messes for my children.
It sounds like it's definitely worth the effort to create a revocable living trust in the long run.
Let's discuss my client we'll call Gary, whose mom died about a year ago. When she passed away, Gary made the arrangements at the funeral home, which you know averages about $7,000 to $10,000, but Gary didn't have the money to pay for the fees himself, so he went to his mom's bank.
I get the feeling it wasn't that easy.
Unfortunately, the bank informed him that he had to be appointed by the court as executor or administrator before they're permitted to release any of mom's money.
And probate is the public legal process completed at the local courthouse that includes completing necessary papers, notifying creditors, and other required steps that can take months to even years, depending on the case.
Right. So Gary decided to call the financial advisor who managed his mom's brokerage account. They were old friends, and Gary was certain he'd do anything he could to help, especially since he knew that's what Gary's mom would have wanted.
Well, could the financial advisor help Gary?
Well, he told Gary that Gary had to be appointed as the executor or the administrator of his mom's estate before Gary could access that account. So Gary decided to use his mom's life insurance policy since he was the sole beneficiary.
So did he hit a roadblock there too?
Yes, because the insurance company needed a death certificate before they could really confirm anything with Gary, and certainly before they sent him a check. And it could take weeks to receive the official death certificate.
So what estate plan did Gary choose for himself after going through all of that with his mother's estate?
He chose a revocable living trust to avoid probate. With all his assets in his living trust, it will be a smooth, private transition with no waiting period when Gary passes away.
Now, revocable living trusts avoid probate. So are they also what we need to plan for Medicaid?
One of the best features of a revocable living trust is its ability to avoid probate. But for asset protection, you need an irrevocable trust.
So what's the difference?
With a revocable trust, you're still maintaining control by being trustee. Think of it as a trustee as a manager. The flip side of that coin is the lack of protection. Assets within an irrevocable trust are protected and guarded by the trustee of your choosing. This can be a good way to prepare for long-term care expenses.
So if someone needs long-term care in a skilled nursing facility, he or she may be eligible for Medicaid. But to receive Medicaid, you need to spend all of your assets down to $2,000.
Right. Any assets, such as life insurance that has some cash value, IRAs, and bank accounts, are usually considered as resources to pay for care before Medicaid takes over. Usually, the home and a vehicle are exempt, at least while the Medicaid recipient's alive.
So if they have property in addition to their home, such as a separate farm or a timeshare or mineral rights, they should consider asset protection because it counts as an asset if they apply for Medicaid?
Yes, and they should consider asset protection for their home because of estate recovery, which is when the government places a lien on a person's home after they've passed away in order to reimburse the state for the money it spent on the decedent's care.
So asset protection is a safe way to avoid losing those important properties.
Right. There are also some deeds that people create to give their children all or maybe just a partial interest in their home to try to avoid these issues.
Do they work?
In some cases, it works out, and in others it doesn't, or it becomes a hassle for everybody involved.
Can you give me an example?
Well, I had a client, we'll call Jane, and when I met her, she was in the nursing home, and she had a home a couple hours away, and she'd given her daughter her home, and she retained the lifetime right to live there. It worked out for quite some time because it protected the home and it permitted Jane to qualify for Medicaid since she had made the transfer more than 5 years before she applied for Medicaid.
Well, that sounds like the plan worked, didn't it?
Well, yes and no. Jane was in the nursing home for over a year, and now her homeowner's insurance wouldn't cover it as a residence any longer, so they had to purchase more expensive insurance. Then they had a water leak and had a lot of damage because nobody was local enough to keep daily watch on the house. The neighbor who had been trying to help watch it felt terrible that he didn't catch it in time.
But that's asking a lot for a neighbor to be responsible, and the daughter was probably too busy visiting mom, working, and taking care of her own family to run down to check on the house all the time.
It was a financial burden too because, you know, Jane could only keep $2,000 in her name and all of her income went to the nursing home to pay for her care, so her poor daughter was paying insurance and taxes and maintenance on her mother's home.
So did they just sell it?
Eventually they did, but even that had complications. Her daughter and son-in-law were having marital problems, but since they were still legally married, the son-in-law was required to sign papers acknowledging that he was all right with them selling the house.
Oh, gosh.
Then Jane still owned a life estate, and the value of it's calculated by the state, and it always ends up being much more than you would think for a person Jane's age. So as a result, she was off Medicaid for a period of time, and then she had to reapply all over again.
That sounds like a very trying experience.
Yeah, they were very frustrated that nobody explained all of this to them when they first set it up.
Would you have been able to offer a better solution?
Absolutely. The home could have been transferred to an irrevocable trust with the daughter as the trustee, and then Jane could have retained the lifetime right to live there. And we could have prevented all of those issues.
Now, I've heard there's a new deed we can use in West Virginia, and I think it's called a transfer on death deed. Would that work?
Well, with a transfer on death deed, the property doesn't actually transfer to your beneficiary until you die. Nothing happens while you're living, so it doesn't create gifting or estate recovery issues.
That all sounds good, but something tells me you're going to tell me there's more bad news.
Well, a significant portion of my time and money are spent staying in touch with estate planning attorneys from all over the country, and I contacted some of them whose states passed this law long before West Virginia to see how it worked in their states.
Well, what did they say?
They said once their state caught up with this planning technique, the state required them to revoke the deed, putting them right back where they started with their property exposed to estate recovery. And now, as of June of 2016, West Virginia is starting to do some things like that as well.
I think you're right. The irrevocable trust removes the risk that all of these other shortcuts can't.
It really is best in the long run.
Well, thank you, Doreen. This is really valuable information we all can use. So, you're probably thinking now, I should contact Doreen and set up an appointment. You're thinking right. You can set up your free consultation by calling 304-554-2900. You can also visit SeamanLawOffices.com or find Seaman Law Offices on Facebook, YouTube, or Twitter. The consultation is free if you want to review your current estate plan or set up a new one. However you go about it, be sure to contact Doreen Seaman at Seaman Law Offices today to see how she can help you. Thanks for joining us today, and we'll see you next time on Elder Care Answers.
Welcome to this edition of Elder Care Answers. Elder Care Answers provides valuable information for senior citizens and those who love them, so we can all be more informed consumers.
Hello and welcome to Elder Care Answers, a show dedicated to finding answers to our elder care and estate planning questions. I'm your host, Mary Ravazio, and joining me is Doreen Seaman of Seaman Law Offices, who specializes in elder law and estate planning. Doreen lives and works in Morgantown, West Virginia, where she graduated from the WVU School of Law. Doreen is licensed to practice law in Pennsylvania and West Virginia, but is currently focusing on the estate planning and estate administration needs of West Virginia residents. Hello, Doreen, and welcome to today's Elder Care Answers.
Hi, Mary. I'm so glad to be here.
Now, on your website, SeamanLawOffices.com, you use the term foundation. What do you mean by that?
Well, I like the idea of the foundation to describe a handful of documents every adult needs to have. This includes a durable power of attorney, a last will and testament, and 3 important medical documents. These are the documents we include in most estate plans because they are so vital.
It reminds me of that old Sunday school song about the man who built the house on the rock and it stood firm.
Yes, like building your house on solid rock, you should also build your estate plan on a strong foundation with the help of an estate planning attorney. This will ensure that you are prepared for life's unexpected turns.
If someone comes to you and says they want a trust, now you don't just hand them a trust document, right?
No, not quite. I help my clients reach their goals, which are very specific to their personal concerns, and that's why I offer a complimentary consultation to get to know them and understand what they'd like to accomplish and what concerns they have. Usually there are issues that are red flags to me, meaning they might not realize there are issues we need to address in their estate plan, but I know from my experience in estate planning.
What kind of issues?
Well, let's use an example. We worked with a couple recently who we'll call the Smiths. They initially came to see me to set up a revocable living trust.
They wanted to avoid probate, right?
Right. When she called to schedule their appointment, Mrs. Smith said they'd already done their research and they wanted a living trust.
It was great that they were already so well informed, though, right?
Definitely. But during their consultation, serious red flags appeared to me. They had